we will be looking at three common law institutions and how they uphold the rule of law: the courts, the parliament, and the government. Let's look at the courts first. The courts are responsible for providing protection to the rights of the citizen against the powers of the government. The courts play their role in three different areas when protecting rights and upholding the rule of law. The first two areas is the articulation of fundamental rights and applying tort law against public officials. In the US, the courts uphold the rule of law because their role is clearly defined by the Constitution. Furthermore, the courts protect citizen rights by interpreting that Constitution. We know that in Britain there is no written constitution. So the question is, what are the bases for protection of further fundamental rights in Britain? From where do the courts derive their power to protect fundamental rights? The answer to both questions is common law. If we look at the basic rights, we can connect the idea of fundamental rights with Dicey's theory that states that the rights flow from the decision of the court instead of a constitution. According to justice laws, the idea of fundamental or constitutional rights coming from the courts provide us with the benefit of protected rights like in a written constitution, and on the same hand, preserving the sovereignty of the parliament and the flexibility of an unwritten constitution. You must have heard the popular phrase that your freedom of movement ends where my nose begins. In common law, people can act freely unless their action interfere with the freedom of others. So the rule of law is upheld when the rights are protected through tort law. So, if a public official interferes with the rights of a citizen, the citizen has the right to bring a claim against the public official. If the public official cannot justify the interference of the right, then the government is bound to provide damages in form of a remedy to the citizen. This has been established by the case of Entick versus Carrington that was decided in 1765. As you can see, the courts are playing a very important role in upholding the rule of law because the courts are providing the citizens with protection from the public officials, hence the government. The citizens are protected from the unlimited powers enjoyed by the government. So the question is, does common law provide sufficient protection to the rights of the people? Let's look at a case to answer this question. In Malone versus Commissioner of Police, the claimant was an antique dealer and was prosecuted for handling stolen goods. From the proceedings of the case, it was established that the police has tapped his phone by obtaining a warrant from the Home Secretary and using the post office to make recordings of his calls. Malone brought a case against the police and the Home Secretary, arguing that the police did not have the power to tap his phone calls. The court argued that Malone cannot seek a remedy because there was no trespass of this property. The court declined his claim for the protection of his privacy rights, stating that there is no protection of privacy rights in common law. So you can see that common law does not provide sufficient protection to the privacy of the people. If you were in Malone's place, how would you have sought protection for your privacy rights? Is there a legal venue other than the common law that can provide protection for your fundamental rights in the UK? After losing the case in domestic courts, Malone took his case to the European Court of Human Rights and argued that his privacy was infringed under Article 8 of the European Conventions on Human Rights. The European Court decided in his favor on the point of privacy. In response to the judgment from ECHR, the government passed legislation called Interception of Communications Act 1985. The Act provides Home Secretary with the powers to tap telephone lines in limited and defined circumstances. So what can we conclude from the following case? Professor Ewing and Geary state that in the case of Entick versus Carrington, the courts were not protecting fundamental rights, but were trying to protect the established property right from trespass. They claim that this can be seen in the later cases, where surveillance was the central issue under discussion. Another criticism that has been made about common law is that common law deals with the rights in a legal manner instead of looking at the rights from a non-legal socio-economic point of view. This can restrict the protection of rights and create a gap between the legal rights and the rights in real world. In the third area where the courts provide protection of rights is through statutory interpretation. The courts use the techniques of statutory interpretation to uphold the rule of law. Courts also apply the principle of legality. What this means is that courts examine a situation very carefully by interpreting the statute. The courts determine what are the powers delegated to a public authority. Is the public authority's claim to interfere with the right of a citizen justified? In R versus Secretary of State for the Home Department, ex parte Pearson, the defendant John Pearson was convicted of murdering his parents. According to the law, the Home Secretary had the power to determine the mandatory life sentence of a convicted person. The Home Secretary, in consultation with the trial judge and the Lord Chief Justice, gave John 15 years. A later Home Secretary revised the decision and decided that the prison sentence should be 20 years. The courts had to decide the question that whether the Home Secretary had the legal power to revise the term of incarceration retrospectively. The courts had to interpret the statute that conferred the power on the Home Secretary. Lord Steyn stated that the Parliament had not expressly given the Home Secretary the power to increase the prison sentence. Otherwise, there would have been no issue for the courts to decide. In the absence of such explicit express powers and by applying the principle of legality from the common law, it is clear that the punishment cannot be applied retrospectively. Lord Hope emphasized on fairness and due process. He concluded that it was against the established rules of common law to punish a person twice for the same crime. Now, let's look at the second common law institution, the Parliament, and how does the Parliament upholds the rule of law. As we had discussed before, that the supremacy of the Parliament and the rule of law can come under competition if the Parliament decided to legislate in a manner that is contrary to the rights of the citizens. Dicey, however, thought that this is not possible, and he states two reasons for that. The first reason is that the English Parliament has three constituents: the House of Commons, House of Lords, and the Crown. Any act of Parliament can only be exercised by the consent of these three constituents. Dicey is trying to establish an argument that the internal working of the Parliament will work in favor of the rule of law when enacting legislation. The three parts of the Parliament will keep a check on each other and will uphold the rule of law. The second reason presented by Dicey is that the English Parliament does not appoint or instruct directly to the government officials. They are only given powers by the Parliament through delegated legislation. The officials are part of the executive branch, that is, the Crown. Here, Dicey is emphasizing the fact that the Parliament is dependent on the executive to further the legislation. In recent years, the Parliament has taken steps to uphold the rule of law when drafting legislation through the Constitution Committee and the Joint Committee on Human Rights. In R versus Davis, the accused was on trial for the murder of two people on a New Year party. The witnesses were reluctant to testify against the accused because of their safety. The trial judge changed the procedure of the trial and limited the cross-question of the accused counsel to protect the identity of the witnesses. The witnesses were also allowed to testify behind screen in the court using devices to distort their voice. The accused got convicted of the murder and appealed the case to the House of Lords, claiming that he was not granted a fair trial by restricting his counsel from cross-questioning the witnesses. The House of Lords ruled in favor of the claimant, stating that the trial judge had no powers to change the trial proceedings because doing so infringed an important common law right. The decision was not popular at that time and got a lot of attention in the media. The Parliament reacted to the media frenzy and rushed a bill through the Parliament, passing the Criminal Evidence Act 2008. The act allowed the judges to make anonymity orders for witnesses. If we look at the case from a constitutional point of view, that the judges upheld the rule of law by sticking to the basic principles of common law trials. On the other hand, the Parliament exercised its powers as the sovereign legislature in the UK and made a clear and express intention to overturn the judgment of the judges. The Parliament is supposed to legislate in a way that is backed by the popular demand of the majority. The Parliament, however, also upheld the rule of law by restricting the judges to follow the fair trial requirements set by Article 6 of the European Convention of Human Rights. We can also look at this whole controversy as being the basic role of these institutions. The courts are supposed to articulate social values and procedures of the whole, and the Parliament is supposed to make changes to these proceedings and make sure that the mandate of the people is being implemented. Another way to look at this whole debacle is through the lens of the rise of security in the aftermath of 9/11 attacks. People are willing to give up their fundamental rights to privacy and fair trial procedure in return for more security from the government. Can you think of a situation where the courts will be not willing to follow a statute enacted by the Parliament? Professor Allen argues that rule of law and democratic principles have the same moral commitment to democracy. The violation of any such rule or law will mean that the democracy is in danger. The Parliament cannot enact legislation that undermines the basic democratic principles that give sovereignty to the Parliament. This kind of legislation will not be upheld by the courts because it undermines the rule of law and the sovereignty of the Parliament. The best analogy will be of a baby who has a bad rash and her hands are covered by mittens, otherwise she will hurt her body by scratching the infected area. Let's look at the third common law institute, which is the government. We will be discussing the role of Lord Chancellor, constitutional reforms, and governmental approach towards upholding the rule of law. Fun stuff! Before Constitutional Reform Act 2005, Lord Chancellor had many roles. Your task is to go online and find all the roles Lord Chancellor was playing. See if you would want to be a Lord Chancellor instead of a Prime Minister, given the kind of powers that were associated with the Lord Chancellor's role. The new Lord Chancellor has a much more limited role, and it may be argued that in the old role, Lord Chancellor was in a much better position to defend the rule of law. The Constitutional Reform Act 2005, Section 1 states that the existing constitutional role of Lord Chancellor in relationship to the rule of law will not be adversely affected. Section 2 states the qualifications required for the position of Lord Chancellor. The section provides a guideline in the selection of Lord Chancellor and also restricts the Prime Minister in appointing a person to the role. The position of Lord Chancellor is seen as a person making sure that the government or the Prime Minister's cabinet is following the law when taking initiatives. Since Lord Chancellor is part of the cabinet, his function is to act as an inside voice to warn the government if it is taking an action that is undermining the rule of law. The role is also responsible for efficient functioning and independence of the courts. Lord Chancellor also holds the office of the Secretary of State for Constitutional Affairs as part of his cabinet role. The Constitutional Reform Act of 2005 is a good example to demonstrate how the government can play an active role in upholding the rule of law and change the constitutional arrangement of the country. Before we go into the details of the Act, let's look at the British government, that is also known as Her Majesty's government. The government is led by the Prime Minister, who selects all remaining ministers. The Prime Minister and the other most senior ministers belong to the Supreme Decision-Making Committee known as the Cabinet. The government ministers all sit in Parliament and are accountable to it. The government is dependent on the Parliament to make primary legislation, and since the Fixed Term Parliaments Act 2011, general elections are held every 5 years to elect a new House of Commons, unless there is a successful vote of no confidence in the government in the House of Commons. In this case, an election may be held in short order. After an election, the monarch selects the Prime Minister as the leader of the party, most likely to command a majority of MPs in the House of Commons. Under the uncodified British Constitution, executive authority lies with the monarch, although this power is exercised only by or on the advice of the Prime Minister and the Cabinet. They also exercise power directly as leaders of the government departments. If we go back to Dicey's defense of the rule of law, we can see that this power is not exercised directly because the ministers cannot order a constable directly. They will have to pass a legislation that will delegate the powers to a constable in the exercise of his duty. The constitutional arrangement ensures that the rule of law is upheld in the exercise of powers held by Her Majesty's government. Let's go back to the Constitutional Reform Act 2005. With this act, the office of Lord Chancellor was reformed to remove the ability of the Lord Chancellor to act as both a government minister and a judge. This arrangement ran contrary to the idea of separation of powers. We will look at the doctrine of separation of powers in more detail later. The Act also provided for a Supreme Court of the United Kingdom to take over the existing role of the Law Lords as well as some powers of the Judicial Committee of the Privy Council. In a symbolic way, the Supreme Court was moved out of the House of Lords in the Parliament and into a separate building to represent the separation of powers doctrine. The Supreme Court is now located behind the Parliament, right across the Parliament Square. See if you can find the Supreme Court on Google Maps. You can also get a tour of the Supreme Court and see some of the judges talk about the institution in this video. Since the Act initiated a big constitutional change, there was a controversy surrounding the passage of the Act. Do you think it was unnecessary to change the job role of the Lord Chancellor and the House of Lords into the Supreme Court? Or are you of the view that these changes were long due and the establishment of the Supreme Court was a step in the right direction? There is another point of view regarding this shuffling of the Lord Chancellor's role. This viewpoint comes out of the decisions taken by the Prime Minister Tony Blair and his cabinet in regards to the constitutional changes, and Lord Irwin's opposition to these changes in an effort to uphold the rule of law. If you think this does not get more interesting, you are wrong. Interestingly, Tony Blair and his wife were the former students of Lord Irwin and worked at a law chamber headed by him. He is also the godfather to one of the sons of Tony Blair. As they say, it's not personal, it's politics.